who might be out there who are still paying for either education or their doctor, their children's doctor. Is it true? They may be paying for the service but not have access to the information that comes from that meeting or appointment.
As a matter of fact, even with divorce cases, if there's not a joint custody award in divorce cases, or even paternity cases, not just divorce cases, anytime children are involved, if there's a custody awarded to one parent, not the other, in order for the other parent to have access to school and medical records, you have to get a court order. You have to actually put that in your order and make sure that that order is given to the physician or with education, the school facility, because they do not have to release those records.
In fact, I believe it's one of the driving forces that shifted Rhode Island from being a state where sole custody was the general norm to one where joint custody, joint legal custody is the general norm, because there were issues raised. The father usually couldn't get medical records, couldn't speak to teachers, and it would be multiplied by the HIPAA and Medical Confidentiality Act today if he doesn't have custody and therefore the legal right to get those records.
Backing up a second, and we talked about doctors, but when you think about this HIPAA law that's supposed to have several covered entities, it is not just the doctor, but what encompasses those entities? Healthcare providers? Is it the Blue Cross? Is it
anybody that works
billing?
in healthcare
Is it, how
setting?
far?
Anyone.
Yeah, it's all
Reaching is
records,
that?
all records
Yeah.
that deal with any medical aspect of anybody's treatment. So it would be doctors, any other healthcare provider, including I would say, physical therapists or nurse practitioners or hospitals or x-ray companies, anybody who deals with medicine, pharmacies, medications, anything to do with your medical situation.
As it pertains to consumers, does that mean that at every step along the way they must talk to the doctor, speak with Blue Cross, United Healthcare, they have to get a written form from the pharmacy, Medicare, Medicaid? Does everyone along the way have to get and issue to the consumer
Well, the
some sort of
doctors
disclaimer?
are now making you fill out a consent form. Anytime you go to a physician, even if you hadn't been to the same physician for years, they're going to make you update your records, and you're going to be signing a consent form that authorizes the physician to release any information to any other provider, whether it be Blue Cross or pharmacy, any other provider.
And what about Blue Cross? Do they have to provide the same disclaimer or the same written information that you sign off on to let them transfer it to another healthcare provider or to a billing company or someone who's subpoenaing records or whatever?
The subpoenaing of records is slightly different than the transfer of information from doctor to referring physician to medical insurance. In order to have Blue Cross, for example, pay your bill, they are going to be entitled to get certain records to make sure it's a covered event. They can't get all your records if it's not related to what's specifically in question, but they're entitled to certain records, and there's a process in place for them to have that. There's a process in place for the referring physician to get the records back from the specialist, so to speak, so that they can treat you. Subpoenas are very interesting because of the Confidentiality Act that's now passed in HIPAA. When you subpoena somebody's medical records, you have to serve the subpoena on the doctor or medical facility that you're subpoenaing the records from, but also provide a copy to the person whose records are being subpoenaed, so they have a right to go to court and move to quash or get rid of the subpoena. So that law has changed to keep up with the changes in confidentiality.
Understanding again that most efforts are driving electronic data. Many doctors are balking at it because they don't have the wherewithal and the time to deal with that as yet, but clearly everything is moving in the direction towards electronic records. Do you think that that is helping HIPAA, or is it really just adding another layer of work and perhaps overburdening an already taxed system, which again is taxing me even more as a consumer?
I think anytime you make changes to any type of system, it's going to add additional work, additional burdens to whomever has to enforce them.
Although I will say this, having seen doctors in action in hospitals that now have those mobile cots that instead of having the big notebooks with all your records in it, have it on a computer, and doctors' offices where they've sort of embraced this technology, once they get used to it, they seem to love it. And it makes your care, I think, a lot better because the records are now so quickly available.
It's much more efficient.
Much more efficient and much more immediate from the time you see the CAT scan company, so to speak, to the time the doctor can go online and get that record. I think the technology can really serve to enhance medical care, and the law can keep up with that because the same rules of confidentiality or whatever that need to apply can apply, and they can be sophisticated enough to secure and encrypt those records so theoretically people can't get at them.
When we talk about records, does it just mean someone's health record, or does it also, and pharmaceutical records, or does it also include even the billing information? Is that part of Privacy Act covered for HIPAA?
I would think it,
Yeah.
I mean, yeah.
Anything to do with your care. So the records that relate to your billing, why would those be protected? Because the billing has diagnostic codes and numbers attached to it that if you're sophisticated enough, you can say, oh, look at that, it was code whatever, I'm not an expert in that, but XYZ, that means that person had such and such a procedure. That's confidential.
Yet, on the other side, we also talk about, it also means that patients have access to these records. That means that as a patient, I am entitled to get the doctor's records, the pharmacy's records, the billing records, correct?
Oh, you own your records, they're yours.
And when a doctor balks at or just delays a little bit too long in getting those records, what recourse? Do we have to go to you
We
to do
actually
something
have
about that?
had situations like that because a lot of times we have the problem of getting the records for a case we're handling. If you have somebody who was injured in an accident but had some
Yes, good example.
pre-existing situation, you need those records. If they balk at them, there's recourse. You can file a claim with the Rhode Island Medical Society or the association that monitors doctors. And they have rules that say that they have to comply. As Jackie said, they're your records. They have to give them to you.
And they can't withhold them because a bill is due either. I mean, they're your records. They can charge you a reasonable fee to produce the records, but they cannot withhold them.
What does the consumer do? Do they, you're saying they don't need to go to a lawyer, they actually can do something themselves. They
Right.
can call.
The Rhode Island Medical Society, the branch of or association that monitors doctors and can reprimand doctors. That's who you go to make sure that they're, just like there's rules for lawyers. Lawyers hold your records, they're your records. If you ask for your file, we need some reasonable time to copy them and produce them for you, but if we don't, you go to the disciplinary council. Doctors have the same type of society association that monitors their conduct.
What happens, we understand that potential employers are not supposed to have access to a person's medical records. What happens if during an interviewing process you are asked such a specific question as it becomes very clear that that potential employer knows that you had a pre-existing condition, which may affect your desirability, let's say.
Now you're
What do you
getting
do?
into the, I think, the Fair Employment Act and
Right.
discrimination. You can't be discriminated against because of a disability or, age and sexual preference. And now you're going into an entirely different area in this labor law and how your medical condition affects your ability to have a job.
But the question you're specifically asking is if there's circumstantial evidence to show that your medical confidentiality has been breached, do you have a claim? Like any other case, there has to be evidence. Circumstantial evidence may not make it, but I'm aware of cases where lawyers have sued employers for going into their employees' records, and they have proof that they did it. And they're liable for doing that just like anybody else would be for breaching confidentiality. The Act says that the person who discloses the information is liable, but I also believe it goes down the level to the person who tried to get the information.